Chapter 4. Usurpation. Article 312. Occupation of real property or usurpation of real rights in property. Any person who, by means of violence against, or intimidation of persons, shall take possession of any real property or shall usurp any real rights in property belonging to another, in addition to the penalty incurred for the acts of violence executed by him, shall be punished by a fine from 50 to 100% of the gain which he shall have obtained, but not less than 75 pesos. If the value of the gain cannot be ascertained, a fine of from 200 to 500 pesos shall be imposed. Article 313. Altering boundaries or landmarks. Any person who shall alter the boundary marks or monuments of towns, provinces, or estates, or any other marks intended to designate the boundaries of the same, shall be punished by arresto menor or a fine not exceeding 100 pesos, or both. Chapter 5. Culpable insolvency. Article 314. Fraudulent insolvency. Any person who shall abscond with his property to the prejudice of his creditors shall suffer the penalty of prison mayor, if he be a merchant, and the penalty of prisión correccional in its maximum period to prison mayor in its medium period, if he be not a merchant. Chapter 6. Swindling and other deceits. Article 315. Swindling, estafa. Any person who shall defraud another by any of the means mentioned here and below shall be punished by: first, the penalty of prisión correccional in its maximum period to prison mayor in its minimum period, if the amount of the fraud is over 12,000 pesos but does not exceed 22,000 pesos, and if such amount exceeds the latter sum, the penalty provided in this paragraph shall be imposed in its maximum period, adding 1 year for each additional 10,000 pesos. But the total penalty which may be imposed shall not exceed 20 years. In such cases, and in connection with the accessory penalties which may be imposed under the provisions of this code, the penalty shall be termed prisión mayor or reclusion temporal, as the case may be. Second, the penalty of prisión correccional in its minimum and medium periods, if the amount of the fraud is over 6,000 pesos but does not exceed 12,000 pesos. Third, the penalty of arresto mayor in its maximum period to prisión correccional in its minimum period if such amount is over 200 pesos but does not exceed 6,000 pesos, and fourth, by arresto mayor in its maximum period, if such amount does not exceed 200 pesos, provided that, in the 4 cases mentioned, the fraud be committed by any of the following means. 1. With unfaithfulness or abuse of confidence, namely, a. By altering the substance, quantity, or quality or anything of value which the offender shall deliver by virtue of an obligation to do so, even though such obligation be based on an immoral or illegal consideration. B. By misappropriating or converting, to the prejudice of another, money, goods, or any other personal property received by the offender in trust or on commission, or for administration, or under any other obligation involving the duty to make delivery of or to return the same, even though such obligation be totally or partially guaranteed by a bond, or by denying having received such money, goods, or other property. C. By taking undue advantage of the signature of the offended party in blank, and by writing any document above such signature in blank, to the prejudice of the offended party or of any third person. 2. By means of any of the following false pretenses or fraudulent acts executed prior to or simultaneously with the commission of the fraud. A. By using fictitious name, or falsely pretending to possess power, influence, qualifications, property, credit, agency, business or imaginary transactions, or by means of other similar deceits. b. By altering the quality, fineness or weight of anything pertaining to his art or business. c. By pretending to have bribed any government employee, without prejudice to the action for calumny which the offended party may deem proper to bring against the offender. In this case, the offender shall be punished by the maximum period of the penalty. d. By postdating a check, or issuing a check in payment of an obligation when the offender therein were not sufficient to cover the amount of the check. The failure of the drawer of the check to deposit the amount necessary to cover his check within 3 days from receipt of notice from the bank and/or the payer holder that said check has been dishonored for lack of insufficiency of funds shall be prima facie evidence of deceit constituting false pretense or fraudulent act, as amended by R.A. 4885, approved June 17, 1967. e. By obtaining any food, refreshment or accommodation at a hotel, inn, restaurant, boarding house, lodging house, or apartment house and the like without paying therefor, with intent to defraud the proprietor or manager thereof, or by obtaining credit at hotel, inn, restaurant, boarding house, lodging house, or apartment house by the use of any false pretense, or by abandoning or surreptitiously removing any part of his baggage from the hotel, inn, restaurant, boarding house, lodging house or apartment house after obtaining credit, food, refreshment or accommodation therein without paying for his food, refreshment or accommodation. 3. Through any of the following fraudulent means. a. By inducing another, by means of deceit, to sign any document. b. By resorting to some fraudulent practice to ensure success in a gambling game. c. By removing, concealing or destroying, in whole or in part, any court record, office files, document, or any other papers. Article 316. Other forms of swindling. The penalty of arrest mere in its minimum and medium period and a fine of not less than the value of the damage caused and not more than 3 times such value, shall be imposed upon 1. Any person who, pretending to be owner of any real property, shall convey, sell, encumber or mortgage the same. 2. Any person who, knowing that real property is encumbered, shall dispose of the same, although such encumbrance be not recorded. 3. The owner of any personal property who shall wrongfully take it from its lawful possessor, to the prejudice of the latter or any third person. 4. Any person who, to the prejudice of another, shall execute any fictitious contract. 5. Any person who shall accept any compensation given him under the belief that it was in payment of services rendered or labor performed by him, when in fact he did not actually perform such services or labor. 6. Any person who, while being a surety in a bond given in a criminal or civil action, without express authority from the court or before the cancellation of his bond or before being relieved from the obligation contracted by him, shall sell, mortgage, or, in any other manner, encumber the real property or properties with which he guaranteed the fulfillment of such obligation. Article 317. Swindling a minor. Any person who, taking advantage of the inexperience or emotions or feelings of a minor, to his detriment, shall induce him to assume any obligation or to give any release or execute a transfer of any property right in consideration of some loan of money, credit, or other personal property, whether the loan clearly appears in the document or is shown in any other form, shall suffer the penalty of arrest mere and a fine of a sum ranging from 10 to 50% of the value of the obligation contracted by the minor. Article 318. Other deceits. The penalty of arrest mere and a fine of not less than the amount of the damage caused and not more than twice such amount shall be imposed upon any person who shall defraud or damage another by any other deceit not mentioned in the preceding articles of this chapter. Any person who, for profit or gain, shall interpret dreams, make forecasts, tell fortunes, or take advantage of the credulity of the public in any other similar manner, shall suffer the penalty of arrest o mayor or a fine not exceeding 200 pesos. Chapter 7. Chattel Mortgage. Article 319. Removal, sale or pledge of mortgaged property. The penalty or arrest o mayor or a fine amounting to twice the value of the property shall be imposed upon 1. Any person who shall knowingly remove any personal property mortgaged under the chattel mortgage law to any province or city other than the one in which it was located at the time of the execution of the mortgage, without the written consent of the mortgagee, or his executors, administrators or assigns. 2. Any mortgager who shall sell or pledge personal property already pledged, or any part thereof, under the terms of the chattel mortgage law, without the consent of the mortgagee, written on the back of the mortgage and noted on the record hereof in the office of the Register of Deeds of the province where such property is located. Chapter 8. Arson and other crimes involving destructions. Article 320. Destructive arson. The penalty of reclusion temporal in its maximum period to reclusion perpetua shall be imposed upon any person who shall burn 1. Any arsenal, shipyard, storehouse or military powder or fireworks factory, ordnance, storehouse, archives or general museum of the government. 2. Any passenger train or motor vehicle in motion or vessel out of port. 3. In an inhabited place, any storehouse or factory of inflammable or explosive materials. Article 321. Other forms of arson. When the arson consists in the burning of other property and under the circumstances given hereunder, the offender shall be punishable 1. By reclusion temporal or reclusion perpetua. A. If the offender shall set fire to any building, farmhouse, warehouse, hut, shelter, or vessel in port, knowing it to be occupied at the time by one or more persons. B. If the building burned is a public building and value of the damage caused exceeds 6,000 pesos. C. If the building burned is a public building and the purpose is to destroy evidence kept therein to be used in instituting prosecution for the punishment of violators of the law, irrespective of the amount of the damage. D. If the building burned is a public building and the purpose is to destroy evidence kept therein to be used in legislative, judicial or administrative proceedings, irrespective of the amount of the damage, provided, however, that if the evidence destroyed is to be used against the defendant for the prosecution of any crime punishable under existing laws, the penalty shall be reclusion perpetua. E. If the arson shall have been committed with the intention of collecting under an insurance policy against loss or damage by fire. 2. By reclusion temporal. A. If an inhabited house or any other building in which people are accustomed to meet is set on fire, and the culprit did not know that such house or building was occupied at the time. Or if he shall set fire to a moving freight train or motor vehicle, and the value of the damage caused exceeds 6,000 pesos. B. If the value of the damage caused in paragraph B for the preceding subdivision does not exceed 6,000 pesos. C. If a farm, sugar mill, cane mill, mill central, bamboo groves or any similar plantation is set on fire and the damage caused exceeds 6,000 pesos, and D. If grain fields, pasture lands, or forests, or plantings are set on fire, and the damage caused exceeds 6,000 pesos. 3. By prison mayor. A. If the value of the damage caused in the case mentioned in paragraphs A, C, and D in the next preceding subdivision does not exceed 6,000 pesos. B. If a building not used as a dwelling or place of assembly, located in a populated place, is set on fire, and the damage caused exceeds 6,000 pesos. 4. By prisión correccional in its maximum period to prison mayor and its medium period. A. If a building used as dwelling located in an uninhabited place is set on fire and the damage caused exceeds 1,000 pesos. B. If the value or the damage caused in the case mentioned in paragraphs C and D of Subdivision 2 of this article does not exceed 200 pesos. 5. By prisión correccional in its medium period to prison mayor and its minimum period. When the damage caused is over 200 pesos but does not exceed 1,000 pesos, and the property referred to in paragraph A of the preceding subdivision is set on fire, but when the value of such property does not exceed 200 pesos, the penalty next lower in degree than that prescribed in this subdivision shall be imposed. 6. The penalty of prisión correccional in its medium and maximum periods. If the damage caused in the case mentioned in paragraph B of subdivision 3 of this article does not exceed 6,000 pesos but is over 200 pesos. 7. The penalty of prisión correccional in its minimum and medium periods. If the damage caused in the case mentioned paragraph B, subdivision 3 of this article does not exceed 200 pesos. 8. The penalty of arresto mayor and a fine ranging from 50 to 100% if the damage caused shall be imposed when the property burned consists of grain fields, pasture lands, forests, or plantations when the value of such property does not exceed 200 pesos, as amended by RA 5467, approved May 12, 1969. Article 322. Cases of arson not included in the preceding articles. Cases of arson not included in the next preceding articles shall be punished. 1. By arresto mayor in its medium and maximum periods, when the damage caused does not exceed 50 pesos. 2. By arresto mayor in its maximum period to prisión correccional in its minimum period, when the damage caused is over 50 pesos but does not exceed 200 pesos. 3. By prisión correccional in its minimum and medium periods, if the damage caused is over 200 pesos but does not exceed 1,000 pesos, and 4. By prisión correccional in its medium and maximum periods, if it is over 1,000 pesos. Article 323. Arson of property of small value. The arson of any uninhabited hut, storehouse, barn, shed, or any other property the value of which does not exceed 25 pesos, committed at a time or under circumstances which clearly exclude all danger of the fire spreading, shall not be punished by the penalties respectively prescribed in this chapter, but in accordance with the damage caused and under the provisions of the following chapter. Article 324. Crimes involving destruction. Any person who shall cause destruction by means of explosion, discharge of electric current, inundation, sinking or stranding of a vessel, intentional damaging of the engine of said vessel, taking up the rails from a railway track, maliciously changing railway signals for the safety of moving trains, destroying telegraph wires and telegraph posts, or those of any other system, and, in general, by using any other agency or means of destruction as effective as those above enumerated, shall be punished by reclusion temporal if the commission has endangered the safety of any person. Otherwise, the penalty of prison mayor shall be imposed. Article 325. Burning one's own property as means to commit arson. Any person guilty of arson or causing great destruction of the property belonging to another shall suffer the penalties prescribed in this chapter, even though he shall have set fire to or destroyed his own property for the purposes of committing the crime. Article 326. Setting fire to property exclusively owned by the offender. If the property burnt shall be the exclusive property of the offender, he shall be punished by arresto mayor in its maximum period to prisión correccional in its minimum period, if the arson shall have been committed for the purpose of defrauding or causing damage to another, or prejudice shall actually have been caused, or if the thing burned shall have been a building in an inhabited place. Article 326a. In cases where death resulted as a consequence of arson. If death resulted as a consequence of arson committed on any of the properties and under any of the circumstances mentioned in the preceding articles, the court shall impose the death penalty. Article 326b. Prima facie evidence of arson. Any of the following circumstances shall constitute prima facie evidence of arson. 1. If after the fire are found materials or substances soaked in gasoline, kerosene, petroleum, or other inflammables, or any mechanical, electrical, chemical, or traces or any of the foregoing. 2. That substantial amount of inflammable substance or materials were stored within the building not necessary in the course of the defendant's business, and 3. That the fire started simultaneously in more than one part of the building or locale under circumstances that cannot normally be due to accidental or unintentional causes, provided, however, that at least one of the following is present in any of the three above-mentioned circumstances. A. That the total insurance carried on the building and/or goods is more than 80% of the value of such building and/or goods at the time of the fire. B. That the defendant after the fire has presented a fraudulent claim for loss. The penalty of prisión correccional shall be imposed on one who plants the articles above mentioned, in order to secure a conviction, or as a means of extortion or coercion, as amended by RA 5467, approved May 12, 1969. Chapter 9. Malicious mischief. Article 327. Who are liable for malicious mischief? Any person who shall deliberately cause the property of another any damage not falling within the terms of the next preceding chapter shall be guilty of malicious mischief. Article 328. Special cases of malicious mischief. Any person who shall cause damage to obstruct the performance of public functions, or using any poisonous or corrosive substance, or spreading any infection or contagion among cattle, or who cause damage to the property of the National Museum or National Library, or to any archive or registry, waterworks, road, promenade, or any other thing used in common by the public, shall be punished. 1. By prisión correccional in its minimum and medium periods, if the value of the damage caused exceeds 1,000 pesos. 2. By arresto mayor, if such value does not exceed the above-mentioned amount but it is over 200 pesos, and 3. By arresto menor, in such value does not exceed 200 pesos. Article 329. Other mischiefs. The mischiefs not included in the next preceding article shall be punished. 1. By arresto mayor in its medium and maximum periods, if the value of the damage caused exceeds 1,000 pesos. 2. By arresto mayor in its minimum and medium periods, if such value is over 200 pesos but does not exceed 1,000 pesos, and 3. By arresto menor or fine of not less than the value of the damage caused and not more than 200 pesos, if the amount involved does not exceed 200 pesos or cannot be estimated. Article 330. Damage and obstruction to means of communication. The penalty of prisión correccional in its medium and maximum periods shall be imposed upon any person who shall damage any railway, telegraph or telephone lines, if the damage shall result in any derailment of cars, collision or other accident. The penalty of prisión mayor shall be imposed. without prejudice to the criminal liability of the offender for the other consequences of his criminal act. For the purpose of the provisions of the article, the electric wires, traction cables, signal system and other things pertaining to railways shall be deemed to constitute an integral part of a railway system. Article 331. Destroying or damaging statues, public monuments or paintings. Any person who shall destroy or damage statues or any other useful or ornamental public monument shall suffer the penalty of arresto mayor in its medium period to prisión correccional in its minimum period. Any person who shall destroy or damage any useful or ornamental painting of a public nature shall suffer the penalty of arresto menor or a fine not exceeding 200 pesos, or both such fine and imprisonment, in the discretion of the court. Chapter 10. Exemption from criminal liability and crimes against property. Article 332. Persons exempt from criminal liability. No criminal, but only civil liability, shall result from the commission of the crime of theft, swindling or malicious mischief committed or caused mutually by the following persons. 1. Spouses, ascendants and descendants, or relatives by affinity in the same line. 2. The widowed spouse with respect to the property which belonged to the deceased spouse before the same shall have passed into the possession of another, and 3. Brothers and sisters and brothers-in-law and sisters-in-law, if living together. The exemption established by this article shall not be applicable to strangers participating in the commission of the crime. Title 11. Crimes against chastity. Chapter 1. Adultery and Concubinage. Article 333. Who are guilty of adultery? Adultery is committed by any married woman who shall have sexual intercourse with a man not her husband, and by the man who has carnal knowledge of her knowing her to be married, even if the marriage be subsequently declared void. Adultery shall be punished by prisión correccional in its medium and maximum periods, if the person guilty of adultery committed this offense while being abandoned without justification by the offended spouse. The penalty next lower in degree than that provided in the next preceding paragraph shall be imposed. Article 334. Concubinage. Any husband who shall keep a mistress in the conjugal dwelling, or shall have sexual intercourse, under scandalous circumstances, with a woman who is not his wife, or shall cohabit with her in any other place, shall be punished by prisión correccional in its minimum and medium periods. The concubine shall suffer the penalty of destierro. Chapter 2. Rape and acts of lasciviousness. Article 335. When and how rape is committed. Rape is committed by having carnal knowledge of a woman under any of the following circumstances. 1. By using force or intimidation. 2. When the woman is deprived of reason or otherwise unconscious, and 3. When the woman is under 12 years of age. Even though neither of the circumstances mentioned in the two next preceding paragraphs shall be present, the crime of rape shall be punished by reclusion perpetua. Whenever the crime of rape is committed with the use of a deadly weapon or by two or more persons, the penalty shall be reclusion perpetua to death. When by reason or on the occasion of the rape, the victim has become insane, the penalty shall be death. When rape is attempted or frustrated and the homicide is committed by reason or on the occasion thereof, the penalty shall be likewise death. When by reason or on the occasion of the rape, a homicide is committed, the penalty shall be death. As amended by R.A. 2632, approved June 18, 1960, and R.A. 4111, approved June 20, 1964. Article 336. Acts of lasciviousness. Any person who shall commit any act of lasciviousness upon other persons of either sex, under any of the circumstances mentioned in the preceding article, shall be punished by prison correctional. Chapter 3. Seduction, Corruption of Minors and White Slave Trade. Article 337. Qualified seduction. The seduction of a virgin over 12 years and under 18 years of age, committed by any person in public authority, priest, home servant, domestic, guardian, teacher, or any person who, in any capacity, shall be entrusted with the education or custody of the woman seduced, shall be punished by prison correctional in its minimum and medium periods. The penalty next higher in degree shall be imposed upon any person who shall seduce his sister or descendant, whether or not she be a virgin or over 18 years of age. Under the provisions of this chapter, seduction is committed when the offender has carnal knowledge of any of the persons and under the circumstances described herein. Article 338. Simple seduction. The seduction of a woman who is single or a widow of good reputation, over 12 but under 18 years of age, committed by means of deceit, shall be punished by arrest au maire. Article 339. Acts of lasciviousness with the consent of the offended party. The penalty of arrest au maire shall be imposed to punish any other acts of lasciviousness committed by the same persons and the same circumstances as those provided in Articles 337 and 338. Article 340. Corruption of minors. Any person who shall promote or facilitate the prostitution or corruption of persons under age, to satisfy the lust of another, shall be punished by prison maire. And if the culprit is a public officer or employee, including those in government-owned or controlled corporations, he shall also suffer the penalty of temporary absolute disqualification, as amended by Badas Pambansa BLG. 92. Article 341. White slave trade. The penalty of prison maire in its medium and maximum period shall be imposed upon any person who, in any manner, or under any pretext, shall engage in the business or shall profit by prostitution or shall enlist the services of any other for the purpose of prostitution, as amended by Badas Pambansa BLG. 186. Chapter 4. Abduction. Article 342. Forcible abduction. The abduction of any woman against her will and with lewd designs shall be punished by reclusion temporal. The same penalty shall be imposed in every case, if the female abducted be under 12 years of age. Article 343. Consented abduction. The abduction of a virgin over 12 years and under 18 years of age, carried out with her consent and with lewd designs, shall be punished by the penalty of prison correctional in its minimum and medium periods. Chapter 5. Provisions relative to the preceding chapters of Title 11. Article 344. Prosecution of the crimes of adultery, concubinage, seduction, abduction, rape and acts of lasciviousness. The crimes of adultery and concubinage shall not be prosecuted except upon a complaint filed by the offended spouse. The offended party cannot institute criminal prosecution without including both the guilty parties, if they are both alive, nor, in any case, if he shall have consented or pardoned the offenders. The offenses of seduction, abduction, rape or acts of lasciviousness shall not be prosecuted except upon a complaint filed by the offended party or her parents, grandparents, or guardian, nor, in any case, if the offender has been expressly pardoned by the above-named persons, as the case may be. In cases of seduction, abduction, acts of lasciviousness and rape, the marriage of the offender with the offended party shall extinguish the criminal action or remit the penalty already imposed upon him. The provisions of this paragraph shall also be applicable to the co-principals, accomplices and accessories after the fact of the above-mentioned crimes. Article 345. Civil liability of persons guilty of crimes against chastity. Person guilty of rape, seduction or abduction, shall also be sentenced. 1. To indemnify the offended woman. 2. To acknowledge the offspring, unless the law should prevent him from so doing. 3. In every case to support the offspring. The adulterer and the concubine in the case provided for in Articles 333 and 334 may also be sentenced, in the same proceeding or in a separate civil proceeding, to indemnify for damages caused to the offended spouse. Article 346. Liability of ascendants, guardians, teachers, or other persons entrusted with the custody of the offended party. The ascendants, guardians, curators, teachers and any person who, by abuse of authority or confidential relationships, shall cooperate as accomplices in the perpetration of the crimes embraced in chapters 2nd, 3rd and 4th of this title, shall be punished as principals, teachers or other persons in any other capacity entrusted with the education and guidance of youth, shall also suffer the penalty of temporary special disqualification in its maximum period to perpetual special disqualification. Any person falling within the terms of this article, and any other person guilty of corruption of minors for the benefit of another, shall be punished by special disqualification from filling the office of guardian. Title 12. Crimes against the civil status of persons. Chapter 1. Simulation of births and usurpation of civil status. Article 347. Simulation of births, substitution of one child for another and concealment or abandonment of a legitimate child. The simulation of births and the substitution of one child for another shall be punished by prison and a fine of not exceeding 1,000 pesos. The same penalties shall be imposed upon any person who shall conceal or abandon any legitimate child with intent to cause such child to lose its civil status. Any physician or surgeon or public officer who, in violation of the duties of his profession or office, shall cooperate in the execution of any of the crimes mentioned in the two next preceding paragraphs, shall suffer the penalties therein prescribed and also the penalty of temporary special disqualification. Article 348. Usurpation of civil status. The penalty of prison shall be imposed upon any person who shall usurp the civil status of another, should he do so for the purpose of defrauding the offended part or his heirs. Otherwise, the penalty of prison correctional in its medium and maximum periods shall be imposed. Chapter 2. Illegal marriages. Article 349. Bigamy. The penalty of prison shall be imposed upon any person who shall contract a second or subsequent marriage before the former marriage has been legally dissolved, or before the absent spouse has been declared presumptively dead by means of a judgment rendered in the proper proceedings. Article 350. Marriage contracted against provisions of laws. The penalty of prison correctional in its medium and maximum periods shall be imposed upon any person who, without being included in the provisions of the next preceding article, shall have not been complied with, or that the marriage is in disregard of a legal impediment. If either of the contracting parties shall obtain the consent of the other by means of violence, intimidation or fraud, he shall be punished by the maximum period of the penalty provided in the next preceding paragraph. Article 351. Premature marriages. Any widow who shall marry within 301 days from the date of the death of her husband, or before having delivered if she shall have been pregnant at the time of his death, shall be punished by arresto mayor and a fine not exceeding 500 pesos. The same penalties shall be imposed upon any woman whose marriage shall have been annulled or dissolved, if she shall marry before her delivery or before the expiration of the period of 301 day after the legal separation. Article 352. Performance of a legal marriage ceremony. Priests or ministers of any religious denomination or sect, or civil authorities who shall perform or authorize any illegal marriage ceremony shall be punished in accordance with the provisions of the marriage law. Title 13. Crimes against honor. Chapter 1. Libel. Section 1. Definitions, forms, and punishment of this crime. Article 353. Definition of libel. A libel is public and malicious imputation of a crime, or of a vice or defect, real or imaginary, or any act, omission, condition, status, or circumstance tending to cause the dishonor, discredit, or contempt of a natural or juridical person, or to blacken the memory of one who is dead. Article 354. Requirement for publicity. Every defamatory imputation is presumed to be malicious, even if it be true, if no good intention and justifiable motive for making it is shown, except in the following cases. 1. A private communication made by any person to another in the performance of any legal, moral or social duty, and 2. A fair and true report, made in good faith, without any comments or remarks, of any judicial, legislative or other official proceedings which are not of confidential nature, or of any statement, report or speech delivered in said proceedings, or of any other act performed by public officers in the exercise of their functions. Article 355. Libel means by writings or similar means. A libel committed by means of writing, printing, lithography, engraving, radio, phonograph, painting, theatrical exhibition, cinematographic exhibition, or any similar means, shall be punished by prisión correccional in its minimum and medium periods, or a fine ranging from 200 to 6,000 pesos, or both, in addition to the civil action which may be brought by the offended party. Article 356. Threatening to publish and offer to present such publication for a compensation. The penalty of arresto mayor or a fine from 200 to 2,000 pesos, or both, shall be imposed upon any person who threatens another to publish a libel concerning him or the parents, spouse, child, or other members of the family of the latter, or upon anyone who shall offer to prevent the publication of such libel for a compensation or money consideration. Article 357. Prohibited publication of acts referred to in the course of official proceedings. The penalty of arresto mayor or a fine of from 20 to 2,000 pesos, or both, shall be imposed upon any reporter, editor or manager or a newspaper, daily or magazine, who shall publish facts connected with the private life of another and offensive to the honor, virtue and reputation of said person, even though said publication be made in connection with or under the pretext that it is necessary in the narration of any judicial or administrative proceedings wherein such facts have been mentioned. Article 358. Slander. Oral defamation shall be punished by arresto mayor in its maximum period to prisión correccional in its minimum period if it is of a serious and insulting nature. Otherwise the penalty shall be arresto menor or a fine not exceeding 200 pesos. Article 359. Slander by deed. The penalty of arresto mayor in its maximum period to prisión correccional in its minimum period, or a fine ranging from 200 to 1,000 pesos shall be imposed upon any person who shall perform any act not included and punished in this title, which shall cast dishonor, discredit or contempt upon another person. if said act is not of a serious nature. The penalty shall be arresto menor or a fine not exceeding 200 pesos. Section 2, General Provisions. Article 360. Persons responsible. Any person who shall publish, exhibit, or cause the publication or exhibition of any defamation in writing or by similar means, shall be responsible for the same. The author or editor of a book or pamphlet, or the editor or business manager of a daily newspaper, magazine or serial publication, shall be responsible for the defamations contained therein to the same extent as if he were the author thereof. The criminal and civil action for damages in cases of written defamations as provided for in this chapter, shall be filed simultaneously or separately with the court of first instance of the province or city where the libelous article is printed and first published, or where any of the offended parties actually resides at the time of the commission of the offense, provided, however, that where one of the offended parties is a public officer whose office is in the city of Manila at the time of the commission of the offense, the action shall be filed in the court of first instance of the city of Manila, or of the city or province where the libelous article is printed and first published. And in case such public officer does not hold office in the city of Manila, the action shall be filed in the court of first instance of the province or city where he held office at the time of the commission of the offense, or where the libelous article is printed and first published. And in case one of the offended parties is a private individual, the action shall be filed in the court of first instance of the province or city where he actually resides at the time of the commission of the offense, or where the libelous matter is printed and first published, provided, further, that the civil action shall be filed in the same court where the criminal action is filed, and vice versa, provided, furthermore, that the court where the criminal action or civil action for damages is first filed shall acquire jurisdiction to the exclusion of other courts, and, provided, finally, that this amendment shall not apply to cases of written defamations, the civil and/or criminal actions which have been filed in court at the time of the effectivity of this law. Preliminary investigation of criminal action for written defamations as provided for in the chapter shall be conducted by the provincial or city fiscal of the province or city, or by the municipal court of the city or capital of the province where such action may be instituted in accordance with the provisions of this article. No criminal action for defamation which consists in the imputation of a crime which cannot be prosecuted as officia shall be brought except at the instance of and upon complaint expressly filed by the offended party, as amended by R.A. 1289, approved June 15, 1955, R.A. 4363, approved June 19, 1965. Article 361. Proof of the truth. In every criminal prosecution for libel, the truth may be given in evidence to the court, and if it appears that the matter charged as libelous is true, and, moreover, that it was published with good motives and for justifiable ends, the defendants shall be acquitted. Proof of the truth of an imputation of an act or omission not constituting a crime shall not be admitted, unless the imputation shall have been made against government employees with respect to facts related to the discharge of their official duties. In such cases, if the defendant proves the truth of the imputation made by him, he shall be acquitted. Article 362. Libelous remarks. Libelous remarks or comments connected with the matter, privileged under the provisions of Article 354, if made with malice, shall not exempt the author thereof nor the editor or managing editor of a newspaper from criminal liability. Chapter 2. Incriminatory Machinations. Article 363. Incriminating innocent person. Any person who, by any act not constituting perjury, shall directly incriminate or impute to an innocent person the commission of a crime, shall be punished by arrest au menor. Article 364. Intriguing against honor. The penalty of arrest au menor or fine not exceeding 200 pesos shall be imposed for any intrigue which has for its principal purpose to blemish the honor or reputation of a person. Title 14. Quasi-offenses. Sole Chapter. Criminal Negligence. Article 365. Imprudence and negligence. Any person who, by reckless imprudence, shall commit any act which, had it been intentional, would constitute a grave felony, shall suffer the penalty of arrest au menor in its maximum period to prison correccional in its medium period, if it would have constituted a less grave felony. The penalty of arrest au menor in its minimum and medium periods shall be imposed, if it would have constituted a light felony. The penalty of arrest au menor in its maximum period shall be imposed. Any person who, by simple imprudence or negligence, shall commit an act which would otherwise constitute a grave felony, shall suffer the penalty of arrest au menor in its medium and maximum periods, if it would have constituted a less serious felony. The penalty of arrest au menor in its minimum period shall be imposed when the execution of the act covered by this article shall have only resulted in damage to the property of another. The offender shall be punished by a fine ranging from an amount equal to the value of said damages to 3 times such value, but which shall in no case be less than 25 pesos. A fine not exceeding 200 pesos and censure shall be imposed upon any person who, by simple imprudence or negligence, shall cause some wrong which, if done maliciously, would have constituted a light felony. In the imposition of these penalties, the court shall exercise their sound discretion, without regard to the rules prescribed in Article 64. The provisions contained in this article shall not be applicable. 1. When the penalty provided for the offense is equal to or lower than those provided in the first 2 paragraphs of this article, in which case the court shall impose the penalty next lower in degree than that which should be imposed in the period which they may deem proper to apply. 2. When, by imprudence or negligence and with violation of the automobile law, to death of a person shall be caused, in which case the defendant shall be punished by prison correccional in its medium and maximum periods. Reckless imprudence consists in voluntary, but without malice, doing or falling to do an act from which material damage results by reason of inexcusable lack of precaution on the part of the person performing or failing to perform such act, taking into consideration his employment or occupation, degree of intelligence, physical condition and other circumstances regarding persons, time and place. Simple imprudence consists in the lack of precaution displayed in those cases in which the damage impending to be caused is not immediate nor the danger clearly manifest. The penalty next higher in degree to those provided for in this article shall be imposed upon the offender who fails to lend on the spot to the injured parties such help as may be in this hand to give, as amended by R.A. 1790, approved June 21, 1957. Title 15. Final Provisions. Article 366. Application of laws enacted prior to this code, without prejudice to the provisions contained in Article 22 of this code. Felonies and misdemeanors, committed prior to the date of effectiveness of this code shall be punished in accordance with the code or acts in force at the time of their commission. Article 367. Repealing clause, except as is provided in the next preceding article. The present Penal Code, the provisional law for the application of its provisions, and Acts Nos. 277, 280, 2480, 518, 519, 899, 1121, 1438, 1523, 1559, 1692, 1754, 1955, 1773. 2020, 2036, 2071, 2142, 2212, 2293, 2298, 2300, 2364, 2549, 2557, 2595, 2609, 2718, 3103, 3195, 3244, 3298, 3309, 3313, 3397, 3559, and 3586 are hereby repealed. The provisions of the acts which are mentioned hereunder are also repealed, namely, Act 666, Sections 6 and 18. Act 1508, Sections 9, 10, 11, and 12. Act 1524, Sections 1, 2, and 6. Act 1697, Sections 3 and 4. Act 1757, Sections 1, 2, 3, 4, 5, 6, 7, First Clause, 11, and 12. Act 2381, Sections 2, 3, 4, 6, 8, and 9. Act 2711, Sections 102, 2670, 2671, and 2672. Act 3247, Sections 1, 2, 3, and 5, and General Order No. 58, Series of 1900, Section 106. And all laws and parts of laws which are contrary to the provisions of this code are hereby repealed. Approved December 8, 1930.